Hi, my name is Therese Wilson. I'm the Dean of Law here at Griffith Law School. Mooting is essentially a mock trial where law students get to act as counsel in a legal case and learn thoroughly a particular area of law in order to apply that area of law to a set of facts and develop and argue a persuasive case for a client. Students learn a range of skills from mooting. In preparing written submissions, they learn to very clearly and concisely articulate legal argument, and then in having to present those arguments orally, they learn to think on their feet, they learn to understand the law well enough to answer a range of questions from the judges, and they also develop their confidence in oral communication.
I chose to study law at Griffith because it offers a range of courses and extracurricular activities which teach you the skills that you will need when you begin to practice law. I chose to moot at Griffith because it allowed me to perfect my oral advocacy skills and network with students and professionals all across Australia and the world.
I chose Griffith because the university provides a range of practical legal experience, from moot competitions to court visits and industry networking. Mooting at Griffith gave me the opportunity to learn from members of the legal profession who help assist the moot team.
So today we have a moot problem based around a defamation case involving a high school teacher and a series of tweets which that high school teacher claims were defamatory. Welcome to this hearing in the matter of Sally Williams and Simon Jones. If I could ask counsel to please announce their appearances.
Your Honours, my name is Milligan, initial S, and appearing with my junior counsel, Bendikill, initial L, represent the plaintiff, Sally Williams.
Thank you, Mr. Milligan.
Your Honour, my name is Purcell, initial R, and with me is De Cruz, initial F, and we appear on behalf of the defendant, Simon Jones.
Thank you, counsel. Mr. Milligan, would you please proceed?
Your Honours, the plaintiff was, until her early retirement last year at the age of 50, a well-respected music teacher at Kings Country High School. Her career was cut short by the stress of having to deal with untrue and cruel slurs against her character, communicated to the Department of Music in Education, Queensland. I seek leave to read and file an affidavit of Janet McIntosh, school principal at Kings Country High School.
Thank you, Mr. Milligan. I'll ask my associate to place that affidavit on the screen, please. Is there a particular part of that affidavit that you wish us to refer to?
Your Honours, I would like to say first that you will note firstly the high esteem in which Sally Williams was held as a music teacher and as a head of the music department. Your Honours, if I could please direct your attention to page 2 of Exhibit A, you will find a letter from grateful parents. It states to Mrs. Williams, "We're not sure whether we ever properly expressed how much we feel forever thankful to you for the help and influence you gave our daughter. You helped her during a time when she felt like she could not achieve anything academically. We didn't know where to turn. You were able to encourage her love of music, and now she is studying at the Queensland Conservatorium and has a bright future ahead. You were able to inspire her, motivate her, and perhaps most importantly, keep her laughing during some challenging times. Now she seems to really enjoy her studies at the university. Thanks for being there, being willing and stepping in." Now, if I could please direct your attention to Exhibit B, you will see the defamatory statements in question, contained in a Twitter feed. These were to the Music Department in Education Queensland, and the obvious inference from the statements made by the defendant are that my client has no talent, was underhanded and manipulative, and that it was her poor behaviour rather than talent which resulted in her being made head of the music department at Kings Country High School. The defendant is the son of the former head of the music department at the school, Jock Jones, and obviously feels bitter regarding the circumstances in which his father resigned from that role. However, there is no basis in truth for the statements made.
Counsel, if I could just interrupt you there, is there any actual evidence of harm to the reputation of your client? Isn't it possible that she's overreacted to really some trivial matters in a Twitter feed?
Your Honour, if I may refer you to a decision of the District Court of New South Wales, which is not binding on this court but which you should find persuasive. It's the case of Mickle and Farley, 2013, New South Wales District Court 295, which involved very similar facts and where damages were awarded without there having to be evidence of damage to reputation. His Honour Judge Alkane, at paragraph 13 of the judgment, stated, quote, "The general damage to reputation is presumed to be the natural and probable consequence of a defamatory publication. The compensation is intended to vindicate the person's reputation in the eyes of the general community and compensate the person for the distress and insult felt. There must be a consolation for the personal distress and hurt caused to the plaintiff by the publication." End quote.
Do members of the general public attach much weight to what's said on Twitter feeds? I mean, it's a noisy environment. People make all sorts of offhanded comments. If something disparaging is said on Twitter, do people take that particularly seriously?
Your Honour, in these circumstances, we submit that people do, because in these circumstances, it was directed to Education Queensland and therefore carries some weight.
Counsel, if I could ask, were the facts of the case you referred us to similar to the facts at hand?
Very similar, Your Honour.
So the defamatory comments, were they similar in that case?
Your Honour, the defamatory statements in that case went somewhat further in that they accused the defamed plaintiff of being responsible for the ill health of another person, as opposed to just manipulating them to leave their job. But the findings in that case are equally applicable, we submit, to the facts before us.
Thank you, Mr. Milligan. We might hear now from counsel for the defendant, Ms. Purcell.
Thank you, Your Honour. Your Honour, what you can see on the facts before you is that statements have been made in a couple of tweets by my client that the plaintiff has manipulated a situation with a view to having my client's father resign from his position as the head of the music department at the King's Country High School. The plaintiff was able to take up that position due to my client's father resigning under a misapprehension that funding had been cut to the school's music department. In fact, the plaintiff was aware that funding cuts had not been made and that the music department could continue to function as usual. I seek leave to read and file the affidavit of Simon Jones.
Thank you, Ms. Purcell. If I could ask my associate to place the affidavit of Dr. Jones on the screen, please. Ms. Purcell, which particular part of the affidavit would you like to draw our attention to?
Your Honour, it is the two exhibits to which we refer to. One exhibit passed from the school principal to my client's father, advising him that funding cuts had been made to the school's music department, and Exhibit B passed from the school principal to the plaintiff, advising that funding had in fact been secured for the music department so that it could continue to function as usual. Your Honour, the important point to note is that the memo sent to my client's father was dated the 15th of December, whereas the memo sent to the plaintiff was dated the 17th of December. The plaintiff was therefore aware that funding had in fact been secured for the music department prior to speaking to my client's father and advising him that she would understand if he resigned given the circumstances. Therefore, the statement contained in my client's tweets were substantially true.
Ms. Purcell, are you suggesting that it was true that Sally Williams was a, quote, backstabbing cow, unquote?
And what sort of evidence have you got to support the fact that she apparently, in your evidence, is a backstabber and a cow?
Thank you, Your Honours. We refer to Section 25 of the Queensland Defamation Act 2005, which provides that it is a defence to the publication of defamatory material if the defendant can prove that the defamatory statements of which the plaintiff complains were substantially true. We submit that the evidence contained in the memos sent from the school principal to both the plaintiff and my client's father evidence that the plaintiff acted as a, quote, backstabbing cow, unquote, as she was aware that funding had been secured, yet proceeded to advise my client's father that she would understand if he resigned, given the circumstances being the funding cuts.
But counsel, don't the statements you're referring to here go further than that in the way that they use such derogatory language? We've got backstabbing cow, we've got snake in the grass. This seems to imply that the plaintiff cannot be trusted at all.
Yes, if Your Honour is of that view, we also seek to rely on the defence provided under Section 31 of the Defamation Act 2005, namely the defence of honest opinion. Subsection 1 of this provision provides that it is a defence to the publication of defamatory material if the defendant can prove that A, it was a statement of opinion rather than a statement of fact, B, the opinion was based on proper material, And C, the opinion was one of public interest. We submit that the statements contained in my client's tweets were one of opinion, which were based on proper material, namely the memos sent by the school principal.
So the author of these tweets was the son. He didn't have any direct evidence of the nature of that teacher. So what sort of evidence and material was the son relying on?
Your Honour, the son was relying on the fact that his father resigned from his position based on the advice and counsel that he had received from his colleague in advising him that funding cuts had not been secured for the music department and therefore that it would be altered in how it could continue to run its course. We submit that the statements contained in those tweets were one of opinion based on the proper material, namely the memos, and that this was a matter of public interest, as it is of public interest whether the plaintiff can be trusted given her role in educating children. If it pleases the court, those are the submissions for the defendant.
Thank you, Ms. Purcell. Mr. Milligan, do you wish to respond briefly to any aspect of those submissions?
Yes, Your Honour. First, there is no public interest to be served by referring to a person as a snake in the grass. Second, counsel for the defendant relies on a statement in Mr. Jones's affidavit that our client told him that she would understand if he resigned, insinuating that she prompted him to resign. This evidence has only been made available to us now, and we therefore seek an adjournment to enable us to obtain our client's instructions on the matter, and perhaps to call Mr. Jones for cross-examination.
Thank you, Mr. Milligan. Ms. Purcell, that's an interesting point that's been raised. Do you wish to comment on the request for an adjournment?
Yes, thank you, Your Honour. In relation to the request for an adjournment, we do not need to rely on the statement contained in the affidavit regarding the conversation between the plaintiff and my client's father, as it is enough to note that the plaintiff was aware that funding had been secured prior to speaking to my client's father and advising him that she would understand if he resigned. With regards to the quote, snake in the grass, unquote comment, we maintain that this goes to the trustworthiness of the plaintiff and that this is a matter of public interest given her role in the education department.
Thank you, Ms. Purcell. Thank you, counsel. We will consider the request for adjournment and deliver our judgment in due course. Today, what you've seen in the moot court is a demonstration of two of our students who actually participated as members of the VIS International Commercial Arbitration Moot Team, representing Griffith Law School in an international competition. Moots take place through the law school curriculum in a range of areas, including contract law, international law, public law, animal law. There are lots of opportunities to apply a range of areas of law in this mooting context. So thank you so much for joining us for our mooting demonstration this afternoon. Now, if you have any questions that you'd like to ask, I would ask you after this finishes in a couple of minutes to please make your way into the chat room, and I'll be very happy to answer any questions that you may have then. And if you would then like to rejoin us here in the auditorium at 5 p.m, we've got a very exciting session coming up. We'll be speaking to two of our remarkable alumni now based in London and Singapore respectively, Tim and Zara, and they'll be talking about their time studying with us at Griffith Law School and then their journey to where they are now in their legal careers working for law firms in London and Singapore. In relation to the video that you've just seen, it is available again on demand within the auditorium. And in addition to joining me in the chat room now, if you do have any further questions that come up, you'll be able to access law school representatives every Tuesday and Thursday between 4 and 6 p.m. During the open house period. There's also the law booth in the study areas hall of the open house site. So lots and lots of things for you to explore if you're interested in studying with us at Griffith Law School. You can also chat to our study advisors between 9 a.m. and 5 p.m. every Monday to Friday by calling 1-800-677-728. That's 1-800-677-728. So thank you once again for joining us. please do make your way over to the chat room if you'd like to ask any questions, and then please do come back to the auditorium at 5 p.m. for our live session with Tim and Zara, which will be followed by an opportunity for you to ask questions live in a Q&A session. Thank you.